I will never be without clientele as long as payday loans exist. The interest rates on them are in the hundreds of percents. 300, 400. I mean, very seldom do these people get out of that cycle.
Hey, this is Chaz Roberts. I'm a personal injury lawyer. It's my passion to bring the law to the people, and that's the purpose of this podcast. You are listening to Law Have Mercy. Hey guys, you're listening to part 2 of my conversation with bankruptcy attorney Chane Menard. If you haven't already, be sure to check out part 1. It's a great episode. Come back and listen to part 2. When it's all said and done, you're going to be an expert in bankruptcy law. I just know it. Thanks for listening. So I think what I'm understanding, other than don't use debt consolidation companies, is if you start seeing yourself going underwater, or you have some type of major bill that comes through unexpectedly, like maybe it's a divorce, maybe it's a medical procedure, an uninsurable medical procedure, when something starts going south.
Divorce
is a big one, right?
Very big one.
You need to start talking to a bankruptcy lawyer sooner than later. It doesn't mean that you're filing a bankruptcy tomorrow. It means that you can maybe start getting your ducks in a row and be educated on the process because you may need to file.
Exactly.
This is juicy. So I want to know why do people going through a divorce, what about that event causes financial issues that lead to bankruptcy?
It's not the divorce in and of itself. It's how they've structured their finances during the marriage. You know, husband works, makes $60,000 a year. Wife has a job, makes $40,000 a year. Well, $100,000 is not a bad income, but these folks will have a house and a car that is usually within that bracket of what people who make $100,000 earn. Instead of having the Toyota Corolla, they'll have the Lexus. And you can afford it. It's affordable. You have one household.
Yeah, you don't have a lot of additional income past that, but
you can afford it.
But you can afford it.
Correct. And now you get divorced. Well, you still have the mortgage note, the 2-3 car notes, the camper note, but now one of these persons has to buy the other out of the house or sell the house. Y'all are each in an apartment or buying a new house. You basically doubling your household bills, but you still have all these other bills. And it just makes it to where the month-to-month amount to pay your bills and your living expenses exceed your means.
And so do the husband and wife become partners in the bankruptcy?
Well, not often. And one of the unique issues with a divorce is if our husband and wife file a Chapter 13, if you get divorced during it, your attorney in your bankruptcy is almost obligated to withdraw and refer you because all of a sudden you start getting conflicts because what's in Chaz's best interest might not be in Chaz's wife's best interest.
Understood.
She might be able to, with no income, just go 7 and walk away, not be paying all this money back for years. Usually by the time they've seen us, they've kind of let it snowball out of control a little bit. Maybe they're getting payday loans. They had loans from every little loan company around town. And it snowballs. And usually by the time they see us, I find it's usually later than they should have. They may do things that negatively affect their bankruptcy, maybe transferring property. There's certain rules on transferring property before you file, things like that.
I've learned a lot about payday loans, and it's pretty shocking to me how common it is in some people's lives.
I will never be without clientele as long as payday loans exist.
What's the layout on that? How does that work?
A payday loan?
Yeah.
Well, there's and I forget the exact.
Now we're going deep, but I just want to know this information.
But there is some state statutes that deal with just these small lenders like payday loans,
like usury laws and whatnot, which
prevent
them from overcharging.
It almost accepts them from the usury laws.
Really?
Which, if anybody's listening, usury is just a limit on how much interest you can charge on a loan. I mean, these payday loans, basically the gist is, I go to Chaz, you give me $500. You loan me $500. Well, I'll write you a $500 check. Or usually there's some finance charge, usually around $55. And next week, we got to keep renewing it every week. But what ends up happening is you get it, well, it's based off of my payday from my employer. Well, if I got to pay you back, but then I also need the money to buy my groceries this week, and I got to pay you back the $50 fee, I can never pay you back. So what happens is I end up renewing this loan every month, every week or 2 weeks for $50, $55, and it just stays there. Then you end up having to get a second one.
So how much do you end up? Let's in your example, you borrow $500 from me. I'm a payday loan supplier or whatever. How much are they actually paying on that $500?
You would pay basically that reinstatement fee every week or 2 weeks until you could pay the whole thing off. Which once you have 2 or 3, you'll never make enough money because you're in the same job to pay them off, and you're just cycling. You're just renewing them every week forever. The interest rates on them are in the hundreds of percents. 300, 400. I mean, it's these insane percentages.
Wow. So borrowing 500 can end up costing you 1,500
easily, because what ends up happening is very seldom do these people get out of that cycle, because you get one, then you end up getting another. Next thing you know, you have 3 or 4, because you're basically borrowing from this one to pay this one, keeping everything going, and it becomes this little cycle with those interest rates you never get out of.
So if I go to bankruptcy court, the second most common face I'm going to see besides yours is a representative for the payday loan people?
It's such a risky lending industry that I think, I don't work for that industry. I've kind of just always assumed from what I've seen that they just kind of know the inherent risk in what they're loaning, and
yeah, they're gonna lose a couple.
That you're gonna lose a few of them.
So my understanding is that student loans are not erased in any type of bankruptcy. Is that true?
There are laws that do allow the discharge of some student loans. That being said, in reality, it doesn't exist. It's what the case laws say. It'll be, you would have to be in a position where you can never pay it back. But then you file on it, and they'll just tell you, well, you might get better at some point, or they can defer it, and they'll never find those circumstances.
So the answer is,
consider it, you're going to owe your student loans.
You're going to owe your student loans forever.
So
now, how is it, Chane? Help me out. We can discharge medical bills, we can discharge credit cards, auto loans, whatever, but we can't discharge student loans, a decision that we made when we were 18, 19 years old.
It's the government subsidized student loans, which they're almost all are now. They used to be dischargeable. And unfortunately, I think it was a lot of maybe doctors, people who had extreme student loans. We're not talking a 4-year degree for nursing. People who went to school for 8, 10 years, they would file bankruptcy after they would get out. So they passed it where these can't be discharged. The government does protect itself a little bit. Taxes are dischargeable in certain circumstances, and in some circumstances not. Student loans, because they're federally funded or guaranteed, they're protected.
The government wants their money back.
Oh, yeah.
Okay.
And, we'll see that too. We'll see folks who go to school for 5, 6 years, undergrad, and they're borrowing insane amounts. And like you say, you're 18, but you're not making the best decisions.
Right.
Definitely not long-term financial. I wasn't.
No. I was fiscally prudent back in the day, but we certainly, I certainly hung around a fair share amount of people who traveled to France on their student loans. I'm not going to mention any names.
And I've seen that. I've had clients who've done things like that. And it's like, well, I thought I could discharge my debt. Not the student loans.
Nope. You handle some businesses. We talked about restaurants. I have one investment rule. I will never invest in a restaurant unless it's McDonald's or Chick-fil-A.
Maybe Cane's nowadays.
Maybe Cane's would be another good one. Todd, if you're listening, give me a call. But no, you have leases, long-term leases, right? Whenever you sign a lease for a restaurant, it's a 5-year lease, a 10-year lease, very expensive numbers. I look at leases in shopping centers and it's $5,000, $10,000. Then you got to buy all the equipment. They buy that on a loan too, right? Correct. A lot of the kitchen equipment, the chairs, the seats. Then you have inventory for food and drinks and beverages. Then you have employees. You have a situation like COVID, or if you're restaurant is not a smash right out the gate, they're in a defensive posture.
Absolutely.
I'm sorry to pick on restaurants, but I'm just thinking of a situation where it could get really bad really quickly.
Usually, if the restaurant itself wanted to file, a corporation is separated from a person. They could file, but that only affects the business, where it usually goes south when it closes the doors. I deal more with individuals, consumer. You may have guaranteed these debts.
Right. A person. So you organize your company as an LLC for the purposes of having the company and limiting your liability, but you're also signing the debts individually in your own name.
Correct. If it was Walmart, I mean, you're going to loan Walmart money, and you don't need one of the Benson family to come and endorse it, personally guarantee it. But a smaller company, if you have a line of credit for your law firm, you probably have to personally guarantee it.
Absolutely.
I do. I did with mine. So when it goes south, if that goes south, well, all of a sudden you're on the hook for all this debt as well too.
That's interesting. What is the societal benefit for allowing a mechanism like bankruptcy in America? What is the societal benefit from allowing bankruptcy?
Aside from that, it's constitutionally allowed for, that bankruptcies are refers to Congress should make laws regarding bankruptcies. It's similar to maybe having a corporation, is to prevent liability. If you're going to invest money in business, the rates of which businesses fail in this country are astronomical, small businesses. I know you had a podcast I'd listened to about a few weeks ago about that. The numbers were staggering. Well, if you want these people to put money into a business and innovate, there's only so much money small business owners have. We have to borrow. You have this dream. You want this ice cream shop. Well, you borrow all this money and you think it's going to work. And often it does work, and you have employees pay all these taxes, and it's a boom for society. But that system has things that don't work sometimes, companies that fail. Well, you personally guaranteed this money. Well, if you didn't have some system for these people to try to at least deal with these situations, nobody would take these risks. You have to have a certain amount of risk for people to put money into an economy and invest and innovate and make these new companies.
And so much so that the founding fathers in the U.S. Constitution put it in there and said, we have to have some type of bankruptcy to support a capitalist nation.
Correct, because sometimes things don't work. They used to have things in the form of, going back hundreds of years ago, debtor prisons. They put you in jail for owing money. Well, you don't always owe money because of some fraudulent act. If it is a fraudulent act, it would be accepted from discharge in a bankruptcy, and it'd be a crime. You could be prosecuted.
Accepted. You would still owe the money.
Correct. There's certain things for like fraud, or there are certain debts other than student loans that are non-dischargeable. Child support. And that's a good thing that child support's not dischargeable because it's to help the other parent who makes less money raise the kids. There's things like if you're intoxicated, OWI. Not the OWI of itself, but if you get in a wreck and you're intoxicated and they can prove it, now they do have to, there's a procedure to have it non-dischargeable. That could be a non-dischargeable debt. I've had clients who've had those.
Yeah.
That follow you for the rest of your life.
Intentional torts are
generally non-dischargeable.
You punch someone in the face and break their face, and there's $100,000 of medical bills. That is a battery. That's not an act of negligence. And
Correct.
So that could potentially be outside of the bankruptcy. That debt would still remain.
That's one that's in, like, it depends what you file, how you file it, what you pay. But in a 7, I think it would be non-dischargeable.
If someone's considering filing bankruptcy, what are the ways that they can really screw up their case before seeing you?
The most common things we'll see is they'll go through a debt consolidation company where they have made payments for a couple of years, removing money from a 401k or retirement account, maybe getting a second mortgage on their house to attempt to consolidate the the debts themselves. Those are some of the main reasons. Or transferring property often is a big issue as well.
Now, Chane, I'm smart, okay? So I'm very smart. So what I'm going to do is I owe a lot of money. I owe $100,000, but I have some property and I have some cars. So what I'm going to do is I'm going to transfer it into my mama's name,
Well,
right? And
correct.
then I'm going to file bankruptcy on the money that I owe. That's a good plan, right?
No.
What? So I'm not that smart now? Am I the first guy that ever thought of that?
Not even close to the first guy who's ever thought of it.
Not even the first guy that today, right?
Not even probably the first one I met with this week who's thought of it. No, well, you know, if I gave my parents a piece of land 30 years ago, it's irrelevant.
Because we didn't think about this bankruptcy.
Correct. The bankruptcy code allows for certain transfers within certain periods of time before you file. And it's usually 2 years under the bankruptcy code, but it may be 3 years or 4 years under state law. And since we're in Louisiana and bankruptcy is federal, but you still have to look at state laws. You know, so for me to know what Chaz owns isn't a federal law. It's Louisiana inheritance law, Louisiana
makes sense.
Property ownership laws. So you transfer it to your, you're going to file bankruptcy next week. You transfer it to your brother, your truck, because it's paid for, it's over the exemption limits, all these things. Well, they could just sue your brother for the value of that truck because you gave it to him for less than what it's worth. There's a test. And now if you sold it to him and there's a paper trail and you sold it to him for what it's worth, there's no harm, no foul.
It's legit. Spot.
Because you got the money, but then you have to, depending on how long the money came into your possession before you filed, you may have to account for where the money went. But other than that, we know you got the money. It's legitimate. You can do that all day long. You just can't give it for less than the value.
So they'll look at 2 or 3 years worth of transfers in the bankruptcy.
Well, they're going to ask you under oath, and you are subject to perjury. And, if you came into my office and said you did it, but you didn't want to list it, I'm not going to file it for you. We're going to list, this is facts, this is what really happened. But certain things like property, you can do background checks on people, know any property that's crossed through their name, real estate versus vehicles. But as far as looking back, they tend to look back about a year. Some of the Chapter 7 trustees, you may provide a year of checking account statements. Not that there's anything wrong in it. They're just looking for anything really, really squirrely in there. There's certain rules in the bankruptcy code about who you can pay, what's considered, they call it a preferential payment. Did you borrow money from your mom and dad, which usually when people get into financial stress, they'll borrow money from family. And who's always the person you're going to pay back? Family, because they'll be there after the bankruptcy.
Right.
Well, unfortunately, if you pay back a family member a debt within 12 months of filing the bankruptcy, they can go back on that family member for that money. You can go back on a regular creditor for 90 days, but you can go back on a family member for a year. So not that we don't want you to pay your family member back, but we don't want to do it done in preference where what good did you do? You filed a bankruptcy and now they're suing your mom and dad who you borrowed the money from to collect what you paid them back.
So the bankruptcy court will try to...
It would be a trustee.
But they'll go after family members where you sent money?
Absolutely.
Wow. You mentioned 401k. I know of people that took an early draw out of their 401k to pay debts, that they had large debts. Why is that a bad thing?
Well, assuming everything else in the case would work out in your favor for the bankruptcy, we have a lot of exemptions, which are protections against seizing property, and there's a lot of protection and exemptions for retirement accounts. They don't want folks to have to go through a bankruptcy and then be on the government dole in 40 years. So there are a lot of protections for 401ks, pensions, things of that nature. Well, you just took this exempt asset, which if you filed a Chapter 7, you still going to have that 401k after with all that money in it. But now you don't have
making interest without taking a penalty payment.
Without taking a penalty payment, paying all those taxes on it.
Yeah.
And now you just paid off all this debt that would have been dischargeable. Now, is it right or wrong to do it either way? financially be in your best interest to do it. Keep the money safe in your 401k.
Yeah, because it could cost you $75,000, $100,000 to pay off $100,000 debt.
It'd probably be more than that once you took the penalties and taxes.
Versus filing bankruptcy, getting rid of the $50,000 debt completely, or coming up with some kind of payment plan in a Chapter 13.
And still have your 401k and retirement.
Without tax penalties, without the early withdrawal penalties, and without taking money that's making money in the stock market and taking it out.
Absolutely.
So that's I never looked at it that way. I've known several people that have taken early draws out of their 401k.
It's a very common that we'll see it, and I understand the motive of the people trying to do anything.
It goes back to like a moral obligation.
It's that moral obligation, anything not to do it.
And potential perceived shame of filing bankruptcy.
Correct. But who really knows if you filed or didn't file other than your creditors for the most part? I mean, it's open court, it's public record like anything else. But in this day and age, people don't have the time to keep up with all that.
The former president of the United States filed bankruptcy multiple times.
As I understand it, corporations, he has filed multiple times. Exactly. And it's not that anyone is trying to, and I used to have a list. I wish I could remember it right now of like notable people over, notable congressmen, former presidents, people who have filed bankruptcy. It's not uncommon when it needs to be done.
So, what about second mortgages and home equity? You mentioned that was a problem for the case.
Okay, maybe you have a house, you have some equity in it. Not a lot, maybe $25,000 of equity in the house. You owe $20,000, $30,000 in unsecured debt, but you may have other debts too that make it unmanageable. Well, you go get an equity loan, you pay off this unsecured debt, and maybe you're still in your financial straits because of other reasons. And I've had this. Then we found it's like you do realize you could have kept this equity in your house. It's protected by an exemption, and you wouldn't have this second mortgage. It would have been what was discharged, or possibly even paid back cheaper in a Chapter 13.
So what you're saying is, if you start running into financial problems, before going to get a second mortgage on your home, a home equity loan,
before that, cashing in your 401k, just go see somebody. Come see us. I mean,
and it's free.
It's free. And you're a good candidate or you're not a good candidate. And if you are a good candidate, maybe you'd want to, and maybe you still choose the other option, but that's with the knowledge of what else could have been done.
Even if you're not a good candidate, you've got some usable information from having a 1-hour cup of coffee with you.
Well, maybe this is how we can make you a good candidate. Maybe you transferred a piece of property 2 years ago and we need to wait 3 years or whatever. Maybe you just need to wait a little bit. There's different reasons you may want to wait. Do it now. What you qualify for, well, based on your income. A lot of what we do, 13.7s, depends on income and what you really even qualify for.
I think you gave us a lot of information about removing the stigma of bankruptcy and how bankruptcy should really be considered when things start going awry in your life situations. What is the biggest misconception you think about bankruptcy?
That I'll never be able to borrow money again. I'm going to have this car I have for the rest of my life. We do Chapter 13s. They could last 3 to 5 years. Cars go bad. You could buy a car while you're in the bankruptcy. Now, it requires court permission and some things, but it's that I'll never be able to get money again or financially be able to borrow money again that like I'll need. When actually the debt lingering on you is probably a bigger anchor on your ability to borrow money in the future than the bankruptcy on your record.
Chane, where can people find you?
We have a website. It's menardlawfirm.com. We're in Lafayette. We have a Facebook site, Menard Law Firm as well. And we have a phone number. Our local phone number is 337-504-3303. We're located downtown Lafayette. We're not somebody who's just trying to video conference with you from out of town to try to do a local case. You're going to sit in my office with me across from my desk, have a cup of coffee, like you said, and we'll discuss it and look at it. And by all means, if we can help you, we'll do everything we can to help you. And if there's another route that's better for you, we'll send you on that other route. It's not about just trying to, take money from every person that comes in the door. Sometimes it's free advice. Sometimes it's free advice and sending them somewhere else.
Awesome, man. Well, I really appreciate you being here. I learned a lot.
I appreciate you having us.
Hey, it would mean the world to me if you subscribe to the podcast and leave us a 5-star review. It helps keep the show free, and it helps us book better guests to provide more valuable content to you. None of the opinions expressed by my guests are that of my own, and nothing we talked about creates an attorney-client relationship or could be construed as legal advice. Hope you enjoy the show.